Hello everyone. Thank you very much for joining this webinar. Today we have Henno and Hannah talking about 10 things to consider before setting up a trust. And in that respect, perhaps can I ask Hannah and Henno to introduce yourself? Perhaps Hannah first. I can see that your background that you're from Trident.
Thanks very much, Alfred, and thanks for inviting me to join today. So my name's Hannah Bisson, and I'm the Business Development Director from Trident Trust in Singapore. Trident's a global independent trust, corporate and fund administration provider. And as for myself, I've been working in the trust industry for about 15 years, and I specialize in planning for ultra high net worth individuals, which often involves trust structuring. So I'm very much looking forward to discussing this topic with you both today.
Great. And Hannah?
Yes, my name is Henno Boshoff. I'm a counsel at Harneys. I'm based in Singapore, and I'm part of the private wealth and trust team, focusing mainly on sort of trust structures for succession planning, corporate trusts, and under BVI and Cayman law. So I've also been in industry for more than 15 years. So it's good to be here and just talk about, the points about for trust.
Yeah. That means that I'm the only one from Hong Kong. Look at my background. Yeah. And I've also been in the industry for more than 15 years. That makes me as young as you guys. And of course, I'm Alfred Ip. I'm one of the Ip of the Hugo and Ip. We have been doing trusts in the state for more than 15 years, although the firm started like around 5 years ago. And for our self-introduction, perhaps we can ask the common question or 10 things to consider before setting up the trust. A lot of people are very interested to know. The first thing is, why? Why do people set up trusts? And Hannah, maybe you can start? What is the common reason why people are setting up trusts, talking to you?
That's a good question. And actually, I think in my experience, when you start talking to families in those early conversations, they're actually quite unlikely to know what exactly it is they need. And they probably have kind of very little knowledge about trusts or settlers, beneficiaries, letter of wishes, or any of these other terms that, we probably use on a day-to-day basis. But for a layman, probably sounds like a foreign language. But yeah, I think for these individuals and families, probably what they do know, or can identify more easily is, what they're worried about. So for me, I find that's usually the best starting point with families. What is wrong? What is their pain point? And once we know that, we can work out how to help them and, what the best solution will be to solving them. And I think, what it tends to boil down to most of the time is probably two main things. The first being, how do I best protect what I have? And the second being, how can I provide for my loved ones if something happens to me? So when you kind of break that down, what it comes down to is asset protection and succession planning. And what we tend to find is that a trust is often a very good solution to both of those problems.
Yeah, I can maybe add, I think in practice, typically in the past, structures are typically used more for tax efficiency. But with the way, clients do live more globally now, it's not as easy to do that anymore. So correct. So from our practice area as well, we see a lot more for asset protection. And interestingly enough, the clients become younger as well because they're more entrepreneurial. They start their companies at a very young age, and they realize the importance of a trust can offer to them. So it's good to see that as well.
Especially in terms of asset protection. I've come across a couple of cases when we are having the young entrepreneur who is like starting an app, probably something like Zoom, and the company float, and suddenly they become multi-billionaires. A lot of time they're actually single. That makes them not only billionaires, but multi-millionaire bachelor or bachelorette. And obviously, doesn't mean that they are going to be a playboy or playgirl, but they do think about getting married, and they do think about getting their assets protected, not only for themselves. Probably they have no issue with sharing all their wealth to their loved one, but they have issue accounting to the other shareholders or investors, because those shareholders or investors are not married to their spouse. and they don't want to introduce a new shareholders into the company, which may have some controlling stake or a power to control or to affect the arrangement of the company, and that is also a very common reason for people setting up trust. And another very common reason is for philanthropy. I mean, a lot of people are more aware of what's going on in this earth, and they want to probably set aside like a sub-trust to look at the cause that they believe in, be it as illness, treatment, or poverty, or environmental protection. I don't know. Do you have any experience setting up a similar kind of trust?
From my side, I mean, yes. I mean, we hear these new terms like sustainable philanthropy, and clients are looking to set up, charitable trusts or for philanthropy purposes, but that has a purpose. It has something, a meaning to that for them as well, and for their maybe what the company believes in and their family. So yeah, it's quite it's good to see that, and philanthropy charitable trusts are set up for different reasons, whether it's for education or religious purposes. But we do see a lot of people looking to look at their legacy that they leave behind, and making sure that family and what they give back to to the world at least is received in a better way than it used to.
Yeah, maybe I can just add to that as well. Whether it's kind of a fully charitable trust, that they've carved out a portion for, or it's just having that ability to, say, distribute a portion of a wider family trust to charity. We kind of see that on quite a regular basis. And some families, maybe they go a bit further, like with encouraging their children and their family to become more involved in that element. Maybe, having family members as part of, say, a charitable distribution committee and making the decisions on what causes that the family can continue to support.
We've talked about all these needs and purposes, but one thing that is most common for our clients to set up trust, and we haven't talked about, is actually tax. Any experience that you can share with us about how to set up a trust that can save tax, and how to achieve it?
That's a tough question to answer, I think, right? But, I think we tend to see that on the tax side, a lot of these ultra-high-net-worth families are probably global, and they have family members living and working in different jurisdictions. So there are ways that, to hold the family wealth more efficiently, and sometimes with professional advice, obviously, and the proper structuring, you can ensure that the assets are compliant in all of those jurisdictions, but still being held efficiently. We tend to find it's not the primary reason that clients will set up a structure. But, obviously, everybody wants to hold their assets and distribute them in an efficient way. So it tends to be part of kind of the peripheral planning rather than the main reason, I think.
I think very important, for, as practitioners, whether we're trustees or lawyers, is educating the importance of tax advice to the clients, because a lot of them do see it as a cost that they don't really want to spend on. But at the end of the day, we do rely on these tax advice, or whether it's global or domestic, for sufficient tax, sufficient sort of planning as well for the structures. Because if it's done wrong, then there's no point. So it's very important. It's just trying to get that across to clients.
Yeah, I totally agree with you, especially for those who are considering moving to a high tax jurisdiction like UK or US. It's very important to have all this in place before they start the relocation, because a lot of time, once they become the resident, a lot of things cannot be done, and it will be too late already. Talking about setting up the trust, a lot of time people would ask how to choose trustee. And in that respect, I think Hannah would be in the best position to give us a few tips.
Oh, sure. Well, now you know me. There you are. Just look me up.
Yeah.
But seriously, I think when it comes down to the facts of the matter, when you set up a trust, the settlor is transferring the legal ownership of a big chunk of their wealth to someone else, to the trustee. So choosing it is, rightly a big decision. So I think as a starting point, selecting a professionally licensed trustee in a well-regulated jurisdiction should give the clients assurance of the trustee's ability to correctly carry out their fiduciary duties, as well as having proper recourse in the unlikely event that something goes wrong. But in addition to this, I would say I think that a key quality a settler should be looking for when selecting a trustee would be their independence. So sometimes, especially for families for who the trust concept is quite new, they might be quite attracted to, say, finding someone who's just going to do whatever they ask them to, or, do things on the cheap and just be like a yes man. But actually someone who just blindly carries out the settler's request could actually end up invalidating the whole trust and the reasons why they're setting up in the first place. So what I think families should be looking for in a trustee, and of course their legal and professional advisors too, are experienced independent professionals, those who will proactively manage the trust, and where it's completely clear then that ownership and control has been fully handed over. And also on an ongoing basis, the settler, I think, would want a trustee who remains involved. So you don't just sign on the dotted line and then file away the trust deed and forget about it. The trustee should not have a passive role. The settler should expect regular contact with them, proactive, not that reactive trust management. A trustee who really wants to get to know the settler, get to know the beneficiaries, so that they can actually appropriately exercise their discretion when they need to. And family dynamics do change over time. So I think this ongoing open communication is essential over the life of the trust.
Clients are becoming a bit more savvy. They do look at the option of having their own private trust company. But even if a client does choose that over an independent trustee, it's very important that they still use an independent trustee, or any trustee for that matter, to help with the administration, because at the end of the day, they may not understand how to do that. So I think whether they maybe in control of their own trustee, having a trustee, an independent trustee for administrative purposes is still very important, just to make sure that they, comply with their fiduciary duties.
I think it is a very good point, especially when private trust company used to be suddenly becoming a very popular option for a lot of clients because they want to retain the ultimate control. But then the disadvantage of it is that in terms of sustainability, if the private trust company becomes the control of a camp of the beneficiaries, the other camp of the beneficiaries have no access and no control, and the one camp of the beneficiaries will want to control it to the exclusion of the other beneficiaries. The other camp of the beneficiaries will be left in a disadvantaged situation, having a lot of difficulties having access to the information pertaining to the trust, and have a level of comfort that the trust will be run properly if the trustee is basically in the control of the other camp of beneficiaries, which is the reason why a lot of dispute may arise. And that emphasizes the importance of having an independent, international, and professional trustee to make sure that the beneficiaries' interests will be looked after. Any discretionary power that will be exercised in the course of the trust will be exercised what we call judicially. That means that with proper reason backing up, taking into consideration of all the interested parties involved, and make a justified decision that can stand the challenge of future beneficiaries through court process. So that's my take. Now that, let's say we have chosen the trustee, who to add as the beneficiaries? Should we add my wife, my children, and the spouse of the children, something like that? Do you have any experience to share?
Well, I mean, as a starting point, there are very few restrictions on who the settler can add as a beneficiary. So they are free to kind of provide for whoever they wish. But of course, most commonly, it would tend to be, the settler's immediate family. And quite often, you tend to find that you may not wish to add, the spouses of your children and your grandchildren, because, going back to that asset protection point, in the event of a potential future marriage and divorce of one of your children, you could end up kind of, diluting the family's wealth outside of the family. So I think probably the most common choice as to, who to provide for in the beneficial class would often be like the lineal descendants of the settler. And then probably also, charities like we discussed before, and, if there's causes that are close to the settler's heart. So maybe I can just add one more point on this, actually. I think, and this is probably, this is slightly related, but one question I actually get asked a lot is, these are going to be my beneficiaries. Do I have to tell them that they are beneficiaries of the trust,
yes,
whoever they are? Particularly if they're just part of a beneficial class and they're not entitled to anything. And I think there are some concerns there. For example, was they're vulnerable? Could they be easily influenced? Or, will it kind of demotivate the children from actually, making something of themselves because they know that they are sat on a trust fund that they will eventually potentially benefit from? So that's quite an important decision too, as well as who should the beneficiaries be. Should they know? Sometimes it could cause more harm than good for some vulnerable individuals. But actually, I think for most families, probably all relationships, really, better communication probably actually solves a lot of disagreements. So I think generally, there is a bit of a risk when beneficiaries are only brought into the picture later, that they might have quite different expectations of what they should receive and how they're going to be provided for. So sometimes actually sitting all the family together, around a table with the settler there, explaining his wishes to them openly during his lifetime might actually be the best decision for kind of the longer term family harmony.
I think managing expectation is the key point here. That actually requires professional trustee to perform the task because they are professional. They are very experienced in communicating with the beneficiaries so that they know their right and manage their expectation. Especially when there is a letter of wishes, in place, they understand what can be done and what cannot be, and they explain to him as an outsider who is totally impartial, who have no vested interest in mind, so that the things that they talk about will be more convincing. Yeah. Typical trust structure. Let's talk about typical trust structure that is normal discretionary trust, compared with all these special trust products like Vista, Star, etc. Henno, can you share with us your experience?
Obviously, being a BVI lawyer, typically the structures we see a lot of in Asia, for example, is the Vista Trust, which is the Virgin Islands Special Trust Act. Now, it's gained a lot of popularity in Asia due to the fact that the trustee doesn't have to manage and control the underlying assets by law. So whoever's the director of the immediate designated company typically manages and controls the underlying assets. Now, this is great for structures where there's maybe operating businesses or very high-risk assets that the trustee doesn't understand or how to manage. And it has a really good place, I think, in some structures. But of course, there's always a downside as well because too much control can also cause tax issues. So it's always important that when clients look at these structures, of course, you can have your cake and eat it, but you need to make sure that at the end of the day, it's not going to come and bite you. So it's always important for that purpose, I think, to take tax advice because we all want as much control as we want to, but if it's not going to be working for that specific individual, then they need to maybe look at a reserve powers trust or a pure discretionary trust. The other point I can just maybe touch on is similar to a Vista, where you can have a lot of control. Of course, something we spoke about earlier is the private trust company. Now, I think that also has a really good place, and the family members can sit on the board and help run their several trusts if there are so many. But at the end of the day, when you sit down, and I think Hannah can also probably agree with this, when you sit down with a family that doesn't really understand a trust structure, and you're trying to explain to them how a PTC is going to be for their benefit, and now you have to go another layer and tell them, oh, by the way, you need some succession planning for the PTC as well, and it just becomes very complicated because it becomes a bit layered. And although it's a perfectly sound structure and it can do amazing things, it's just that I think clients get a little bit, threatened by this. So it's just something to evaluate with each client as well.
Yeah, especially, I remember once we talked about private trust company and then to be held by a public trust without any beneficiary. Right. This all sounds brilliant, but at the same time, it seems very complicated. It probably would be quite difficult for the family to understand.
And that's very typical, to have the purpose trust hold the shares of a PTC. I mean, mainly that's for succession planning for the PTC structure, so that if any individual shareholders had to pass away, then it wouldn't go into their estate, and you have to carve out the trust. But there are other ways as well to maybe mitigate that, maybe with joint tenancy or with rights of survivorship. But I mean, ultimately, the client also has to be comfortable with it and understand why they're paying 2 layers of trustee fees. But it has a good way. I think for big families that have a lot of trusts, maybe under a private trust company, it's really good to look at these structures because you want to make sure it carries on and there's continuity. Yeah.
Yeah, maybe I can add to that as well, because I do agree with everything that you've said in terms of private trust companies. I think maybe in the last few years they kind of gained a lot of popularity, and I think some families thought this was just the best way to keep as much control as possible without really realizing what a PTC is. It is a trust company, so the decisions that PTC board makes have to be fiduciary, and also they need to have proper governance, proper record keeping of those decisions, and consider things like where is the actual mind and management of the PTC. If most of the directors are the family members and they live in another jurisdiction, could they actually make the trust resident there? So there's a lot more to think about with a private trust company than just, okay, this is a great way to keep everything, within the family. But yeah, I mean, like I think Henno just said, I think for those larger families, where they're properly advised, they have multiple trusts, and they also want, to build in, governance and succession, kind of all levels of the structure, and committees and the trustee, etc. I think it definitely has a place for those families, but it needs to be properly understood and properly run.
So in other words, private trust company is something that is like advanced level, that unless the family are very familiar with the trust and how it operates, it is not advisable for them to set up a private trust company so casually. We have spent a lot of time trashing, in a way, trashing for private trust company. But can I ask, let's say a typical discretionary trust with a reserve power for the settler. What is the usual reserve power that you have seen that would be popular among the settler?
Maybe from my side, I mean, the most common power that we see when we draft a reserve powers trust is really to reserve the powers to the investment management. I think that's something that clients do like to control in many ways, and they want to make sure that they can continue being actively involved in running the underlying assets, sort of, whether it's just from a point of investment or giving advice or suggestions. So this is probably from our side the most common reserve power that we see.
And Hannah, how do you see this reserve power? Do you consider it welcomed, or is taking away the discretionary power that usually would be available to the trustee?
I mean, on my side, it's exactly the same. It's usually the investment powers. I mean, under Singapore law and under a majority of kind of trust jurisdictions, there are carve-outs that say, the settler can retain these powers without invalidating the trust. And usually, the control over, how and what to invest in is the one that the family wants. And I think, as long as, as long as that's understood and the responsibilities are understood from the outset, then it enables the settlor to continue to manage the assets during their lifetime, but they still benefit from the protections that you get from the trust structure, and by giving up obviously the legal ownership and handing over the other decision-making powers to the trustee. So yeah, I think it is a good balance.
When a power is reserved for that manner, is to always make sure that one looks at the succession planning for that power. So whether it remains with the settlor, and then when he, passes away, it goes back to the trustee, or if you would like to, provide that power to go to someone else as well. It's just something to keep in mind when working with clients.
Talking about protection, Hannah, what is protector? This is something that, like in the old structure, is not very common, but it's becoming more and more common. Can you share with us what is it and how is it come by? Why is it necessary?
So I think, actually, very uniquely under BVI law, the role of a protector is actually in the legislation. So, thumbs up there. But I think, very typically, obviously it's an optional power to bring in a party to bring into the trust deed. So when you do meet with families, you can explore this with them. But essentially, a lot of clients do like to have the protector power in their trust deed, just because it allows them to sort of almost have a little bit of in a way, a consenting power when the trustee has to make certain decisions, whether it's distributing, assets or making investment powers. At least they are there just to give a consent to that and be part of the discussions. Now, obviously the role of a protector is quite fiduciary, because you need to act in the benefit of the beneficiaries. So I think in practice, we do see settlers wanting to be appointed as protector. I think because during their lifetime, they want to make sure that the trustee is actually, following their duties, and they want to just be there to monitor it in a way. However, it's always good to explore having someone more independent, I think, because at the end of the day, if you're too close to your own sort of like, how do I say this? If you may not act independently if you're acting for yourself, right? So these are little things to consider. But I think something we see a lot more now in practice is protector committees, just because it allows you to appoint maybe 2 or 3 more people to act in a committee, and they together will then vote on certain powers. And I think this is a good way, because it just gives a little bit more independence. And also you can clearly have a succession planning in place as well. So, typically the trustee will make provision for a successor, protector, or later on, you can always do it by deed. But no, I think it's quite popular. It has a place. It just depends on maybe the family and whether the need of a protector will help them. So this is just something I think to look at a case by case basis.
And Hannah, who are the popular protector that the clients would choose to add this fiduciary role, which sounds quite important?
As Henno said, probably the most common would be probably the settlor themselves during their lifetime, or someone that is close to the family. So another family member or someone who's close to them that they trust and that knows the family more intimately, so that they have that assurance that someone is monitoring the trustee and that the decisions are being made with the full knowledge of the family situation.
Have you seen any professional acting as protector, and what's the benefit of it?
Yes, I have. I think it's probably still less common than a family member, or it tends to be more common perhaps at a later stage in the trust, where at first the settlor might be that individual, but when they're no longer around, they might want somebody to continue that role, who will be completely independent and professional. So whether that's one of the family advisors, etc., who can carry out the role completely independently. Particularly as a family where they don't have somebody that they completely trust within the family to be independent, then I think that would be a good alternative.
We also see corporate entities being appointed as protector. And I think there's nothing wrong with that, because you can actually have a board of directors, obviously, on the protector entity. But something to keep in mind is that, wherever the entity is incorporated, it may be regulated. So when a client does appoint or incorporate a corporate entity as the protector of a trust, they need to make sure that there's no legislation that's going to restrict that entity.
Understood. And I believe that one of the major role of a protector is to have the power to veto if the trustee decides to make distribution. In this respect, can I ask, how does trustee make the decision over when and how much to make a distribution? Hannah, can you share this with us, your experience?
Yes, sure. I think, the trustee's decisions, in terms of how and when to distribute, are fiduciary decisions. They have to be in the best interest of the beneficiaries. So usually there are two ways that it can be set out. So either in the trust deed or in the letter of wishes. And I think it's a kind of a balancing act between, what needs to be codified within the trust deed itself, and what should be in the letter of wishes, which can be updated more regularly as the family situation changes. So I think it's probably better not to be too specific in the trust deed itself. I've had discussions with some settlers where they want to build in restrictions like none of my children can benefit before they are 40 years old, for example. But what happens is, you hard code that into the deed, and the settler's no longer around, and their child loses their job, or their business goes under, and they struggle to put food on the table for their children, but they can't access the trust fund because they're only 38. So it wouldn't be what the settler had intended. So I think flexibility in leaving the trustee quite broad, and leaving the discretion to the trustee as into how and when to distribute to the beneficiaries enables them to then deal with a changing situation in the family over generations. What the settler can do is provide his letter of wishes, which is more informal guidance as to how the settler's expectations are for providing for the family, how they should, when he would like them to receive distributions, etc. And that, as it's informal, as it's guidance, it can be updated, as often as needed, to deal with the current situation and requirements of the family.
Hannah, do you help clients draft into some letter of wishes? And what would be the usual guidance that you would give to the client when you are taking instructions?
Letters of wishes is something that, a lot of families don't really see a need for, because they think, oh, well, you know what, the trustee knows us, they understand, what we're trying to achieve. But essentially, letters of wishes, although it's not legally a binding document, and the trustee still has discretion to follow it, it's really there to help the trustee understand the family. And also, a lot of times, let's face it, trustees change. People, the trustee companies itself, and they may not have that relationship with the client. So it's important I think, to have these letters of wishes, at least, some information as to what the settler is trying to achieve. So I think when we discuss this with clients, it's really just to come down to the points of, what are they trying to achieve long term? Is there any distributions they want to be made to beneficiaries when they reach a certain age? Or maybe they want to have a specific distribution if a family member goes to college, or if they want to start their own business. There's so many variations, and each person is going to be different, right? And it's important, I think, just to come down and have something in writing for the trustees, so they know going forward when the settler is no longer there, that at least they are on the right track as well, and they understand what they need to do with the sort of trust fund itself.
Yeah, it's actually a very, to me, a very serious document, because it is an expectation management between the settler and the trustee, and how the trustee can manage the expectation of the beneficiaries. It has to be well documented so that the trustee understands the context, where it is from, why the trust was set up, and what's the ultimate goal in order to let them perform the role and make all the discretionary power, exercise all the discretionary power in view of such what we call primary goal. Yeah. Yeah. Okay. Now let's talk about what is it that people will settle into the trust in terms of trust assets. Perhaps Henno, you can give us some example.
Of course, it's going to come down to really, I think, the trustees, just, the risk appetite as well, right? So I think a lot of times, typically we see bankable assets, real estate, but even real estate can be quite, onerous sometimes depending on the jurisdiction. So, of course, then you get the higher risk assets like, airplanes, yachts, art. And now, as the world has changed, we now look at cryptocurrency and all these things, that potentially can go into a trust. There's nothing wrong with that. However, it's going to come down to the trustees also understanding the asset and making sure that they can manage it accordingly, and making sure that, in fact, they can help make it, a long-term asset for the trust as well, and for the benefit of the beneficiaries. I think we've all seen how the crypto market's gone, and although we do see trustees now taking on crypto assets, it is very high risk because the assets can go down in value overnight. So I think from an offshore perspective, we probably see a lot more higher risk assets, just mainly because of the risk appetite of certain jurisdictions. But I think also as time is moving on, a lot of the jurisdictions that sort of focused on mainly sort of bankable assets and very, very sort of vanilla assets are now understanding also the importance of taking on higher risk assets because the world has changed so much. So, I mean, this is sort of what we see from our side.
Yeah, maybe I can just add to that as well, because I think you're right. That the kind of the most typical or common trust structure would probably be holding bankable assets. You mentioned other, as you term, higher risk assets, and I think in my experience, in our opinion, as an independent trustee, what we always want to do is give the clients the best solution possible. So why give them kind of like a partial solution just for the cash, but not something that will protect probably the assets that might even be more important to them if it's their business that they've built up, etc. So I think what's important in terms of reducing those, mitigating those potential risks is understanding, what it means to hold those assets. So, from our perspective, what's most important is that, the client gets proper advice around structuring those assets and how to hold them in a trust, what the ongoing obligations might be of holding them under such a structure. And if, they are properly advised and it's properly structured, then it should be possible to do so with most asset types.
And if I may ask a very direct question, Hannah, what is it that you don't take on as trust assets?
Well, I mean, obviously nothing illegal, nothing that you can't take the title to. But, I have seen, pretty much all of those assets that Henno mentioned in terms of, real estate, private businesses, artwork, yachts, planes. It's possible to do with, the client being well advised on the structuring first, yeah.
I think also it's about the flexibility of the trustee. We've seen a lot of independent trust company, which is like your company, which is much more flexible on this compared with the trustee company run by the bank, which is only interested in the bankable assets. I think this is how you compare with the other bank trust company, right?
Yeah, I mean, I think, for an independent trustee, this is what we do. Being a trustee is our business. So we want to give a kind of holistic solution as possible for clients, and that usually involves not just their bankable assets. So, we want to find the best solution. So, like I said, with proper advice, then, it's possible to do so.
Another common question that we have come across is whether to set up a inter-vivos trust or a will trust. To me, I always say that, of course, it would be better to set up an inter-vivos trust because at least you can decide when to set up the trust, when to put in the trust assets, and what are the terms, and run it through so that you have a peace of mind over setting up the trust in the course of the lifetimes, that the beneficiaries will be properly protected and the trustee will run it properly under your supervision. Compare with the will trust, that is basically to instruct the executor to set up a trust for the benefit of the beneficiaries after he passed away and use the assets to settle in. The settler would never know what would be like after when the executor set up the trust, because he or she would be 60 under. Yeah. In that respect, do you have any experience to share, or would you agree with me about this?
I can maybe, I think from experience, of course, a lot of my practice is drafting wills, and I think for BVI and Cayman for that matter. But we do see, clients looking to do wills trust, mainly because they don't want to set a trust up now, maybe because of costs, and they prefer it to be established at the time of the probate when it happens. I mean, it does have its hurdles because you need to potentially agree a trust deed in its normal, it's sort of a standard form, but also it's sort of finding a trustee and preempt them that perhaps, you will become trustee of this this trust, which will happen in a few years' time. And conditions may change, fees may change, the deed may not be as appropriate then. So these are all things we do see. I mean, yes, we can. You can draft the will and annex the trust deed as an annexure to say that this will apply. But it has a lot of issues that you need to iron out and discuss with the family. I think from a practice perspective, I think having the trust set up initially and just having it there with a nominal amount of trust corpus waiting for the assets to be transferred at the time of probate is probably a lot better, because the family can be comfortable with the trustee that's being appointed. They know it's reputable, and all these things can be planned. They can agree the fees. So I think this is probably the pros and cons, but it really depends on the advisor, the person who's doing the structuring. And I do know in Singapore, for that matter, a wills trust is very popular. So, it just depends on the clients. But yes, I think if the trust can be established, it's probably a lot easier from a practice.
Yeah, maybe I can add to that as well. One other concern about, a will trust or the assets being added to a standby trust on probate is that you don't have that full surety as you would if you've set up a trust during your lifetime. What happens if, say, the will is contested, and then there's a long drawn-out legal battle between the family members that could have been avoided if the trust was already in place, well before that time.
It is very valid, especially when we are dealing with so many will disputes. Setting up a will trust, what if the will is being challenged later or being interpreted? This is actually become a very costly process. Yeah. Another question that actually I want to throw to Henno, because obviously you are the offshore lawyer, so you have the distinct benefit or the point of view. Whether to set up the trust onshore, offshore jurisdiction, or in another way, what is the benefit of setting up the trust in an offshore jurisdiction like BVI, Cayman, Jersey, or Guernsey?
I'm going to be very impartial here because I don't want to, I think, we all work together in the industry. And I think, obviously, can be quite biased. Obviously, I'm a BVI lawyer, but I think, it's really going to come down, as much as I want them to set up offshore trusts, or whether, they do onshore, it really depends on the clients, their needs. And it's really putting that first. And I always tell clients, when they come to us and discuss offshore structures, is they need to also look at the onshore or midshore options, because there may be some benefits for them that they don't know or understand yet. And the only way is to understand several jurisdictions and understanding what they can offer. Obviously, there's a lot of, clients come to us and say they want to have their trust, in existence for eternity. Now, eternity is a very long time. And for example, BVI perpetuity period is 360 years. And surprisingly, that's not long enough for a lot of clients. I like to tell them, I don't know if the world's going to be here in 360 years, but I mean, that's where they look at other jurisdictions where there's no perpetuity period, because for them, it's a dynastic trust, it's going to continue forever. But then, of course, they also need to understand that when you have an offshore trustee, you can't just go and meet them whenever you want to. You need to, it's going to be a bit of a, troublesome affair. But if they have a Singapore trustee, for example, it's easier. It's just easier to go meet them face to face. So, it really depends. Of course, there's a cost issue as well. Maybe, offshore can be a little bit more flexible with costs. So there's so many things that you got to look at. But I think essentially it's going to come down to the needs of the client, whether it's going to work from a tax perspective. That's always key, I think. Can't get around that. And also what's going to be more practical for them, language, all these things. There's so many elements that play key. And I think you need to just weigh those up. Yeah.
And Hannah, is there any jurisdiction that you're not going to be able to offer this trustee service?
Well, I mean, all of the key kind of offshore jurisdictions that Henno just mentioned, I think they all kind of have a lot of similarities to each other. So like I said, sometimes it comes down to just the client's preference or familiarity, rather than choosing one over the other. But I think generally it'll start with what the client needs, and then whatever's right for them, then we'll look at the solution for that, whether it's having a trustee and everything, the day-to-day administration fully based in one of the offshore jurisdictions, whether it's a kind of say Singapore-based trustee, but using the proper law, for example, of a different jurisdiction. There are kind of all manner of options available. So it's again, it'd be like Hannah said, it would be looking at what's right for the client and their situation first.
So it doesn't really matter whether the trust is a BVI trust, Cayman trust, or a Singapore trust, or even a Hong Kong trust. Trident can help.
Yes, correct. Yeah.
Brilliant. I speak your elevated speech for you. And the only one thing that I want to add in terms of choosing jurisdiction is that it very much depends on the purpose of the trust. And I think most of the onshore jurisdiction can already provide adequate protection, especially if you want the trustee to be in the same jurisdiction. Probably the trustee may be more familiar with, for example, a Hong Kong trustee may be more familiar with Hong Kong law, and the Singapore trustee will be more familiar with Singapore laws, and etc. BVI or Cayman, probably some of the work would be onshore in the offshore sense. Is because they have to be licensed to act as a trustee in that jurisdiction. That's why some of the work has to be done there, and there will be time difference, there will be language difference, and all the other consideration. So it is something that we always walk through with the client when they are choosing which jurisdiction to choose, which is the other reason why we are here to help out giving an impartial view over which jurisdiction to choose. And in terms of choosing jurisdiction, of course, one of the questions that a lot of clients will ask is, what's the fees? How much is the difference? And when you talk about money, it can become nasty. Hannah, how do you approach this question when client asking, how much is it? How much does it cost?
Generally, I think clients get a little bit of their eyes, they raise when you mention trust fees, I think, because they start thinking, oh, I'm going to pay this every year. And how long am I going to live? They start calculating in their head. But I think clients need to see it as an investment, because at the end of the day, it's planning for their future succession for their family. And it's going to give them so much protection, whether it's asset protection, succession planning. But you're right, clients are a lot more savvy. They want to compare fees. They want to understand what are they going to get for their fees. They want fixed fees. They don't want time spent. It's so many things now. But ultimately, I think, trustees also have a lot more responsibility now in the sense of, compliance and, the way the world has changed for reporting purposes. It's becoming, more and more sort of, duties on the trustee side. So I think clients just need to understand that they're receiving a benefit for the trustee fees, and, they should see it as a positive. And so, yes, these things do come up. You just need to educate clients and make them see the benefit, I think, going forward. Yeah.
And Hannah, when client asks you about fees, how would you react?
Yeah, I mean, very, very, much what Hannah's just said. I mean, a trustee is not just a custodian. They should be involved. They should be proactive. So you need, the right trustee with an experienced team who will do the job properly. So that won't necessarily be the cheapest one out there that you can find. So it is a bit of an education process, educating the client in terms of what the trustee's role is, what their responsibilities are, what you should expect them to provide on an ongoing basis and why that's important. And then, I think then we get to a point where they're comfortable with that. And then they would be comfortable with a fixed fee, usually, as Henno said as well, for the trustees' service on an annual basis.
If I were you, I would simply say, we are not the cheapest, but we are the best. Just like your signature.
I'll try that next time.
Well, we have covered a lot of points in relation to setting up the trust, what things to consider, and what to think about. Having you today is really wonderful, because all these are actual experience helping clients through setting up the trust. So I think that next time when the client is coming to you, I hope that they have the opportunity to check this video out first, and perhaps most of the questions will be answered. Thank you very much for today and your sharing. It is brilliant, and we can do something like this in future, and I'm sure that it will be as exciting as this one.
Thanks very much, Alfred.
Thank you, Alfred.
Thank you, and have a good day.